Hello, treasured viewers, and welcome back to our channel, Human Rights Heralds, with your usual anchor, Ogochukwu Onoha. Welcome to a quarter hour with the Human Rights Wizard. In today's video, we'll move into the episode 10 of our series on human rights. And our focus today is on tenancy and the law of contract, the human rights perspective. You will agree with me that tenancy issues is one that affects everyone. It cuts through all strata of our society. The poor, the rich, the very poor, and the very rich. If you are not a tenant, then you are possibly a landlord. Therefore, the tenancy law also affects you. And if you are not a tenant or a landlord, then possibly you are a sibling in a family where the parents are tenants in a property belonging to a named landlord. And if you're not a landlord, possibly you are the daughter, the son, or some relation of a landlord. Therefore, tenancy issue affects everyone, irrespective of your social standing. One way or the other, the tenancy law also affects you. Today, we want to talk about tenancy and the law of contract because it is one area where many citizens are vulnerable, especially those citizens who are tenants in someone else's property. It is often in issues relating to tenancy that the fundamental human rights of many citizens are trampled upon or violated, which is why it is so important that we know something about the tenancy law and how we can go about protecting our rights. May I remind you once more that this is Human Rights Heralds and that this channel is dedicated towards helping us to become better citizens by understanding our rights in the law and the duties which the law has imposed on us, and how to go about navigating through our duties and through our rights in such a way that we do not trample upon other people's rights, but rather help them to live their own rights in full, while at the same time encouraging them to observe and help us to reap the benefits accruing from our own rights. Therefore, we will begin by asking you, my esteemed viewer, to like, share this video, and subscribe to this channel so that we will be more able to give you videos of this nature. There are many people out there who, left on my own, may not be able to see this video. But if you become a part of the distribution chain, you have done a great service, not to yourself alone or to me, but to the entire nation. We will begin by talking about some elementary theories of contract, some of which we learned in our secondary school, just as a reminder. So begin by asking, what is a contract? A contract is an agreement between two or more persons who have the intention to get this agreement enforceable in a law court. Now let us take this simpler. if an agreement between two persons or more includes the intention to have the agreement enforced by a law court, then this is known as a contract. So enforceability is a vital element of a contract. So a contract cannot be valid and therefore cannot be called a contract. An agreement cannot be called a contract if the intention to enforce its provisions in a law court is not included. The parties or the people who are engaged in an agreement are known as parties. Therefore, a contract is an agreement between two or more parties with the intention to enforce it in a law court. That is what a contract is. There are some conditions that make a contract valid, including its enforceability in a law court, which I've already mentioned. The other one is that there has to be an offer and there has to be an acceptance. An offer means a proposal. And the proposal can be made in writing. It can be made by speech. It can be made by conduct or action. The person making the proposal is called the offeror. Offeror, that is someone making an offer or proposal, is called the offeror in law. Every day, we engage in multiple agreements without knowing that this is the case, that we do it unconsciously. Some of them are contracts, many others are not. I'll give you an example. Each time when, as a buyer, you ask the price of a commodity and are told, and eventually pay and take the commodity, there has been a contract. Because the seller who has displayed some commodities for sale is making an offer through his or her action. Then a buyer who buys and pays for the commodity has accepted the offer and has made the payment. What this means is that the contract has been initiated and performed. Each time you see a commercial driver on the road driving, there is an offer. If you hail down the taxi or bus, for instance, and get on board, you've accepted the offer. So there is a valid contract. So the driver now has the duty to take you to the named destination, and then it is your duty to pay for the service. And then the contract is said to have been performed. These are very minor contracts. Now let us ask the big question again. In these contracts I've mentioned, is there an intention to enforce it in a law? Is there the enforceability intention behind it? Yes, even though the parties do not often understand this, they are not often conscious of it. I am sure many of us have had this experience of a commercial vehicle who is under duty to take you to a destination that he has mentioned and which you've told him about, decides somewhere on the road that he wouldn't go there anymore and decides to refund you a part of the money you paid, or decides to put you in another commercial vehicle to complete the journey. What if you reject? Usually there will be a quarrel. Now, how do we interpret the driver's action? We can interpret it as a breach of contract. We're going to talk about this. A breach means that someone has violated the rules of the contract. Of course, the passenger can sue the driver, but these are minor issues. Most of the times, passengers assume it's unnecessary, wasting their time going to court to make such a claim, because the amount of money or the loss resulting from the injury is usually minimal. So in law, we say someone has slept over his rights. Yes, it is not every right that one has in the law that has to be claimed. Sometimes the expenditure of time and money that would be involved to claim a certain right is far higher than the advantages derived from claiming such a right. So what do we do? Because a violation of such a right does not cause much harm either to our person or to our property. So usually the right thing is to slip over it. That means to allow the matter to fizzle away without doing anything. So let us review what we've already said. A contract exists if there is an agreement between two or more parties, including the intention to enforce that agreement in a law court. And it involves a person known as the offerer making a proposal or making an offer by word of mouth, by action or conduct, or in writing. And it involves a second party accepting the offer. The second party accepts the offer because there is a value which the offerer is proposing to give the offeree. That is the language in the law. For the other party who accepts an offer, that party is called the offeree. Remember that the first party, the one who makes the proposal or offer, is called the offerer. So there are offerer and offeree. So if the offeree accepts the agreement or accept the offer, this implies that there is a valuable consideration which the offerer has pledged to give to the offeree. Assume that the offeree performs certain action associated or attached to the deal. So between offerer and offeree, there is valuable consideration. What is valuable consideration? A consideration is something that a person has pledged to give to another person if that other person performs certain duties associated with an agreement. So, the landlord has offered to provide a living accommodation. That is the valuable consideration. A living accommodation that includes all the facilities that will make a tenant comfortable living in the apartment. That is the valuable consideration. But to enjoy this valuable consideration, the landlord has named a certain amount which the tenant must pay weekly or fortnightly, that is every 2 weeks, monthly or every 6 months, or annually or every year. This amount that the tenant is to pay, amount of money, usually known as rent, is the duty which the contract has imposed on the tenant. The performance of this duty gives the tenant the right to enjoy the valuable consideration offered by the landlord, which in this case is the apartment and all the facilities attached to it. These are aspects of the elementary theories of contract that we should have in mind when we are entering into a tenancy agreement. If one of the two parties or more in a contractual relationship fails to perform the duties which the contract has imposed on him or her, or has imposed on them, then in law it is said that the contract has been breached. So to breach a contract means to fail to perform one or more of the duties that the contract has imposed on you as a party to that contract. And when this happens, in law, it is said that the other party has suffered an injury. If a tenant, for instance, consistently fails to pay his rent, that amounts to a breach of the tenancy contract. And that amounts to an injury done on the landlord. And in a tenancy agreement or contract, it is usually enough ground. It is usually enough ground for the landlord to begin to take steps to seek redress for the injuries he has suffered. Good. A related term is performance. If the contract is performed, then all parties are satisfied because all parties have performed the duties imposed on them by the contract. And then we say that the contract has been performed and then could expire because it has come to an end. The other is negligence. A party has neglected his duties in the contract and it becomes a breach again, which could lead to the termination of the contract by the other party. Now, so much for these legal aspects of the tenancy agreement, which it is my hope you have thoroughly understood. So we can now focus our attention properly on the contract between a landlord and a tenant, or a landlord and a tenant to be, a landlord to be and a tenant to be. What must you do as a tenant to protect your rights? First of all, you need to know what the rights of the landlord are and observe those rights. That's an important step towards protecting your own rights. The rights that the tenancy contract imposes, or the rights that the tenancy contract confers on the tenant, are duties that the landlord must perform. And the rights that the tenancy contract confers on the landlord are duties that the tenant must perform. Let's get down to the nitty-gritties. Let's talk about duties of a tenant in a contractual agreement between the tenant and the landlord. Duties that the tenant owes to himself and duties that the tenant owes to the landlord. First, a tenancy, the tenancy agreement provides that rent is to be paid retroactively, but not proactively. I would like to address these two concepts. When we say proactive, we mean beforehand or ahead of time. When I say retroactively, I mean later, after the event. Let me break this down further. And before I do so, I'd like to remark that while it is true that the tenancy law in the country, in various states of the country, is in a written form. The provisions of this law are not set in stone. They are not to be rigidly applied. Because of this, a landlord and his or her tenant can have an agreement outside the tenancy law. That means they could agree on an aspect of the tenancy which is not written in the law, and the agreement is binding on them. It is the reason why in Nigeria, rent payment is proactive. What I mean by proactive is that we often pay the rent for our apartment before we move in. We pay to spend a year in the apartment. We pay to spend 6 months in the apartment. And we do this even though the law provides that the rent should be paid retroactively. That means you must have occupied the apartment for a period of time before you pay the rent. So if a tenant is a 6-monthly tenant, you have to live in the apartment or in the flat, whichever one it is, for 6 months. It is at the end of 6 months that you are expected to pay the landlord. But because in Nigeria, both the landlord and the tenants seem to prefer that the rent is paid first, it has become a binding contract between them. And most Nigerians follow this, but this is not the provision of the law. So usually we pay before we move into an apartment. That's acceptable because it's an agreement between the landlord and the tenant. So let's now take a look at the other aspect. So if you are moving into an apartment as a tenant and you would prefer to move into the apartment first and stay for a year before you pay as a yearly tenant, you can agree with your landlord and this will be reflected in your contract. But first, before you rent an apartment in somebody's property, you need to be sure that an agreement is written. Do not just move in because there is a vacancy there and someone has facilitated you're moving into the apartment. Anything could happen later. So you must have to be patient and get the agreement written. Now what should you do? Engage a lawyer who will meet with the landlord's lawyer. I understand that this is contrary to the practice in Nigeria. Usually the landlord would ask you to pay the rent and pay a lawyer's fee and pay an agent fee. Very often, the landlord is the same person as the agent and the lawyer. And by so doing, they often defraud the tenant. The landlord's lawyer shouldn't at the same time be the tenant's lawyer. The right thing is to engage your own lawyer. The landlord will engage his own lawyer, and both lawyers will meet and draft the tenancy agreement between the landlord and the tenant. The landlord's lawyer will draft the agreement because the landlord is the offeror. The tenant is the offeree. Then on the tenant's behalf, the tenant's lawyer will go through the agreement and explain some technical or legal jargons that may not be understandable to the tenant, to him or her, and make sure the tenant understands the words of the law, the words of the agreement before it is signed. Then, apart from your lawyer being a witness and countersigning on your behalf, you need to bring 3 other witnesses. Okay, or 2 if your lawyer is already one of them, to make it 3. And the landlord should do the same. they will all endorse the tenancy agreement and have copies each, so that if there is an attempt at fraud in the future by any of the parties, all the witnesses could bring their copies as evidence of the original agreement entered by the two parties involved. That is that part. If you do this, you are protecting your right as a tenant. Now, there are some practices that, as a tenant, you need to avoid. Practices that could lead to a breach of the contract between you and your landlord. The first is this: do not overcrowd the apartment given to you. Because of this, ab initio, at the beginning, the landlord will want to find out how many persons are occupying the apartment. Maybe a flat. The flat is built for a family. If you are a family man and you are to live there with your family of 4 children, including you and your wife, bringing the number to 6. A family of 6 children, including the man and his wife, bringing the number to 8. It is okay in a flat, for instance, so the landlord knows from the beginning how many persons are moving into the apartment. Now, if it is a 2-room apartment, a 1-room apartment, declare the number of persons who will occupy the apartment, so that the landlord will be able to verify whether the facilities in the property can accommodate that number. Because overcrowding an apartment usually puts enormous pressure on facilities like kitchen and bedroom and toilet suites, so that over time these facilities begin to deteriorate because of overuse, because its capacity is lower compared to the pressure to which it is subjected. That is one. Secondly, declare your purpose of renting the property. If it is for business, you have to declare the kind of business. If you do not do this, and eventually it is discovered that you are using the apartment you rented to sell contraband products or to engage in activities that are not legal in the law. Selling hard drugs like heroin and cocaine and marijuana in an apartment could constitute a breach of the tenancy contract. Now, if you are a tenant in a property which you share with other tenants, and you are a young woman, and every hour of the day, the other tenants keep seeing young men driving in and out to pick you. One picks you, comes back, and in a few hours, another comes and picks you in a car and comes out again. So young men keep visiting you. Parents in that apartment, the other tenants, might begin to see your behavior as a bad influence on their children, on the children they are raising in that property, and there are rights. There are rights. If they complain to the landlord, it could be enough ground for the landlord to try to recover his property from you and eject you. What if you are a drug addict and your fellow addicts come to your apartment, and every time people in the property perceive the odor of hard drugs that you smoke with your friends, this, of course, makes you constitute a nuisance to the rest of the tenants and could be interpreted as a breach of contract. In addition, do you keep late nights when other tenants are in bed by midnight? Sometimes you come knocking on the gate and forcing them out of their beds to open the door for you. That is wrong. That is wrong behavior and could also constitute a breach of contract. What about fighting and quarrelsomeness? You keep fighting and quarreling with other tenants over every issue. It could also result in a breach of contract. And then you have a poor hygiene. You are disposed to poor hygiene. You mess up the environment. You pour dirty water everywhere, inviting flies. You throw refuse about in the property, and when there is an arrangement for general sanitation, you refuse to take part. You are a nuisance to the other tenants who prefer a clean environment. And if they complain, this can be interpreted by the landlord as a breach of contract. So all of these, and more, including subletting your property, subletting your apartment. Is it legal to sublet? Yes. You can sublet, provided there is no clause in the tenancy contract forbidding it. That is why many landlords are quick to include the clause. They don't want you to be in their property and become a junior landlord in the property. You are given an apartment and then you sublet it to some other persons. If you must sublet, tell the landlord that you want to sublet. You want to share the apartment with others, and it becomes a part of the agreement. And it is known from the beginning that these are the number of persons who are co-tenants with you in the same apartment and who will be sharing the rent with you. But don't do it in the absence of the landlord or without his knowledge. If you observe all of this and you pay your rent on time, then you are actively protecting your right as a tenant by performing certain duties to yourself and the others to the advantage of the landlord. Now, those are the duties of the tenant. What are the duties of the landlord? Now, the landlord has the duty to give you the apartment he has promised. If you have observed all the duties imposed on you by the contract, the landlord should give you the apartment and should not disturb you while you are living in that apartment. All right. Because of time and space, we will be taking a second video on tenancy agreement and the law of contract. In that second video, we'll be talking about the duties of the landlord to the tenant and the legal redresses available to the tenant if his rights, one or more of his or her rights, have been abused by the landlord. That will form our focus in our next video. For now, I hope you've enjoyed our video today. If you have done that, if this is the case, then please share and subscribe to this channel and like this video so that we'll give you more of this kind of a video. Remember that our goal remains to create awareness on human rights by helping you to understand your rights in the law and how to go about defending, protecting those rights. So I say, know your rights, protect your rights, and defend your rights. I'd like to see you in our next video. Bye-bye.